Welcome to Tennessee Court Talk. The topic of this podcast is indigent representation, and it will review how several states meet their constitutional obligations to provide attorneys for defendants who cannot afford an attorney. Before we begin, let's review where the right to have an attorney even comes from. The Sixth Amendment of the United States Constitution states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and to have the assistance of counsel for his defense." In the case Gideon v. State, the United States Supreme Court held that if a defendant cannot afford an attorney, the state must provide one. In the case, the court specifically said, governments, both state and federal, quite properly spend vast sums of money to establish machinery to try defendants accused of crime. Lawyers to prosecute are everywhere deemed essential to protect the public's interest in an orderly society. Similarly, there are few defendants charged with crime who fail to hire the best lawyers they can get to prepare and present their defenses. That government hires lawyers to prosecute, and defendants hire lawyers to defend themselves. This is the strongest indication of the widespread belief that lawyers in criminal courts are necessities, not luxuries. The right of one charged with crime to counsel may not be deemed fundamental and essential to fair trials in some countries, but it is in ours. From the very beginning, our state and national constitutions and laws have laid great emphasis on procedural safeguards designed to assure fair trials before impartial tribunals in which every defendant stands equal before the law. This noble idea cannot be realized if the poor man charged with crime has to face his accusers without a lawyer to assist him. Hosting today's podcast is Joe Byrd, who is the lead attorney managing Tennessee's Indigent Representation Fund. He is joined by the Chief Justices of several states, including Chief Justice Laurance VanMeter of Kentucky, Chief Justice Valerie Stanfill of Maine, and Chief Justice Marla Luckert of Kansas. Let's join the conversation to break all this down.
Hi, I'm Joe Byrd, lead attorney for the Indigent Services team at the AOC. Very pleased to have today three Chief Justices from different states that have different structures. And Chief Justices, we first appreciate the privilege of you taking time out of your schedule today to meet with us. But my post has allowed me to kind of look at how each state is different. And truly in the United States, each state is structured differently in how they take care of indigent representation. It's organized differently. Some have robust public defenders. Some delegate it to counties. Some have a mixture of that. Some are under the judicial branch. Some are under the executive branch. And all three of you have your states are unique among the three, and even different from Tennessee. But the one thing that the three of you have in common is that you were trial judges, where you saw how important appointment or however indigents were being represented in court was being done. Maybe we could just start off and you give us a little idea of how things are done in your state and how important even our listeners may need to know a little bit about the importance of the constitutional importance of the indigent being represented.
Marla Luckert from Kansas. We have a mixed system in that we have a statewide public defender system for our felony level cases, but a county system for our misdemeanor and other cases. And within our our public defender system, we really also have a mix there because our public defender offices are located mostly in our highly populated areas, so they're very concentrated on the eastern part of our state. The western part of our state remains largely using private attorneys, and of course we use private attorneys throughout the state for conflict and for overload as well, because our funding is not robust, and as a result of that, our public defender offices often exceed case limit caps, and at that point then we also turn to the private attorney sector.
I would say that probably that's another thing all states share in common is funding is always an issue to some extent. So, Justice VanMeter, what about Kentucky?
Okay, in Kentucky, we have a statewide Office of Department of Public Advocacy that is funded by the legislature. It is statewide. It covers felony cases, misdemeanor cases, juvenile cases. Does not cover family cases. Typically, family cases are court-appointed guardian ad litems locally, and they are typically, the guardian ad litem cases typically get $500 per case, that's problematic in and of itself. There is a system for contract attorneys in the event of a conflict, and typically I've traded notes with our director of public advocacy, Damon Preston, who I'm sure you know. He said that's actually a problem because the best contract attorneys are former DPA attorneys, and they know the system and they know they can get more money out of being a contract attorney than they can from being a staff attorney at DPA. So it's changed. So when I first became a judge in the 90s, the two largest jurisdictions are Louisville and Lexington, and they were county systems, which was not attached to the Department of Public Advocacy, but that changed probably about 15 or 20 years ago. It was all rolled under the executive branch agency. I think it's under the Department of Justice.
So even Louisville is under that now?
Yeah, it's all under that.
Okay. Justice Stanfill.
Until, I think, 2 years ago, we were entirely court-appointed from the private bar. We had no public defender system at all. And that the public defender system now is really just beginning. We have 4 what we call rural defenders who started taking cases about a year ago. And they're trying to establish a brick and mortar system, and that's just starting. I think this fall they hired the first public defender for that. And again, it's only funded for a handful of lawyers. So we are entirely still just about dependent on the private bar. And the private bar, and I'm sure this is true for everyone else, is shrinking, especially in rural areas. It's more stratified. There are fewer and fewer people willing to take it. We have now a roster of people willing to take cases in whether it's criminal cases or to represent parents in child protective cases or juveniles. And that roster at one point last week or so was, I think, amounted to 30 attorneys in the entire state willing to take these cases. So we are really in a crisis at this point. The judicial branch still appoints the guardians ad litem. Although we have a pretty robust right to appointed counsel in these cases, we give parents counsel from the moment a case is started in child protective. We give all juveniles appointed counsel. And you're entitled to appointed counsel even in misdemeanors if there's even the potential of a jail sentence. We're not doing a good job on it.
What you don't want is you don't want the system to run rampant over someone. So that to me informs the importance of indigent representation. You want people to have the best representation they can have so that the system does not run rampant over them.
Yeah. Justice Luckert, we kind of in the round, you may want to even address some of the things that got addressed from the other justices, because I don't think we got a chance to hear the juvenile and how that works in Kansas, and also this concern of finding private counsel that's willing to take the cases and the shrinking numbers in rural counties. Would you like to give us what's going on there in Kansas for you? We kind of got into that a little bit, but maybe a little more.
Certainly. The juvenile system is set up so that it is appointed by the judges at the local county. So that our chief judges in those counties go to their county commission and argue for a budget for this. And the smaller the county, the harder the argument, I believe. But even in our largest counties, most of those attorneys are making only about $80 an hour. Some maybe go up to $120. But certainly not what they would be making if they were billing a paying client or expecting to pay there. And so we do have an incredible problem finding people who are willing to take those cases. And even moving up, we do have experience qualifications for certain levels of cases. And to find people with those that can meet those criteria and take cases at those hourly rates just is a mismatch. The other issue is that, as you have mentioned and others have mentioned, our rural shortage is incredibly difficult. We have counties where we do not have attorneys. And so we have actually are doing better today than we did pre-COVID because we've learned the power of remote proceedings. And so we can have attorneys from our public defender's office on the eastern part of the state at least assist in those cases and provide some benefit to that. Recently was talking to an attorney, a public defender, who had appeared in 4 different counties in one day. It would have taken him a week to do had he been in a car, but was by remote proceeding was able to do that. But even in our urban counties, the attorneys that are willing to take the cases is a very small number. And what I see or saw, I see now in transcripts, but saw when I was in the trial court, is that often that means we're attracting very inexperienced criminal attorneys and frankly do not do the quality of representation that you see in the experienced public defenders. And that's a broken system.
I'm going to jump in on that because interestingly, as I say, we're virtually entirely dependent on appointing people from the private bar. And the rate of pay was really problematic. It was not too long ago, it was $60 an hour, and then it was raised to $80 an hour. And giving credit to our legislature and our governor, they've taken action, and last year it was raised to $150 an hour, which for appointed counsel is a pretty high rate. And the problem, I echo what Chief Justice Luckert says about the remote proceedings. We do that too. Part of the reason we're doing as much remotely as we are is to accommodate, the attorney from Portland who's willing to take a case all the way at the other end of the state. But that wreaks havoc as well, trying to get people into the courtroom for proceedings that they need to get into the courtroom for, or to make proceedings effective. Because, the reality is sometimes when you don't get everybody into the same room, it's just not effective. So it has its own, we're doing the same thing, but it has its own problems.
What's your system?
So we have a public defenders that are locally elected in each judicial district. So we don't have a unified public defender's office. We do have a public defender's conference that provides administrative support, but they often get conflicted out. And so we find our trial courts have to appoint private counsel. And when they do, it's under our Supreme Court Rule 13. We're sort of like Maine was and like Rhode Island is now. It's under the judicial branch. And so and it's administrated through the Administrative Office of the Courts, the funding mechanism and the payment process. And then in the juvenile cases, there is no agency overseeing any of that. So the local court has to appoint the attorney for the parents and guardian ad litems, and then they're paid under the structure, which is a billable hour structure under Rule 13 of the Tennessee Supreme Court rules.
So in Chattanooga and Hamilton County, you have a person who's elected as the local Hamilton County public defender, right? And then so does in the larger counties, so that person will have an office.
Right. Yeah, and it's of course the conflicts come very often. It could be because the public defender represented the co-defendant or represented the victim, as often these cases go. Can happen, and so we actually see quite a few misdemeanors and felony cases where appointed counsel happens. We average anywhere between 80,000 to 100,000 claims per year that come through our office in both juvenile and criminal court. And of course,
wait, so they're paid local? They're paid from a central repository in Nashville?
Yes. So right. So we're funded by the legislature, and it's in the judicial budget.
We always thought that was a conflict, which is why we fought so hard to get it out of our budget. We are a unified court system, so it wasn't like, with the exception of a probate court, but you had judges trying to appoint counsel and then approving their bills or disapproving their bills, knowing that we didn't have enough money in our budget to pay other bills as well, and it felt like that was a conflict, that judges were tempted to cut the payments, or where it really, I think, sometimes came in is the approval. You had to get court approval of the ability to use funds to hire private investigators or experts or something. And, again, every time we approve that, it's like, okay, that's out of our budget, and now we can't pay other things. And so we tried really hard, and successfully at least, to get the administration of the system out of the judicial branch.
So I think the way that Tennessee kind of works around that conflict is twofold. Number one, there is a set budget for indigent representation that's from the legislature. It's a set amount, and our role is primarily just administrative. So we're just going through and looking at, did they check all the boxes and comply with Rule 13, and then we can go ahead and make the payments, based on that. It's really an administrative role that we play. And then the second thing is that we don't have a unified court system. So the local judges make the appointments, and they also, most of our, so for instance, funding on investigators and experts, the court has to approve by an order showing that there's a particularized need for that expert, let's say. But then what the rule requires is that the AOC takes a look at it from an administrative standpoint. And then we'll take a look at it, making sure that it complies with Rule 13 and that,
So you're appointed by the Tennessee Supreme Court?
Me personally?
Yeah, you.
Yes. Yeah, okay. I'm appointed by I'm an employee of the Administrative Office of the Courts, and what my role is as designated by the director is looking at that administrative side of things, and that's really all we do. We don't get into a substantive analysis. That's done by the local trial court, and so we work hand in hand with them. So I think I don't know that we completely take care of the conflict, at least not the apparent conflict that's there, but I do think that's sort of how we navigate that a little bit more. It's a little different, our role different from the budget being separate, and the fact that what we really have is an administrative role. And that would be interesting. I think all three of your states have separate agencies that manage this. Is that right?
Right.
We have, it's truly called a Board of Indigent Defense Services. It's an executive branch body, but with the board as the governing body. And that board is made up of appointees from the governor. By statute, it caps the number of attorneys that can be on the board. They want non-attorney participation. And so that board then hires the executive director of the agency. So that part is separate, but we do run into those other issues when we get to the misdemeanors and the juvenile and GAL, guardian ad litem appointments, because we still have all of that happening at that local level by our judges. Many of our larger jurisdictions, though, in those areas have gone to a contract. So they will have, depending on their size, 5, 7, 8 attorneys that the county contracts with as essentially full-time employees. And so we do, even at that level, have kind of a mix of how that's happening. And most recently, our county with the largest number of criminal cases used ARPA money to take a law firm and basically pay that law firm to do the work on what we called a resolution docket that really moved through cases that had backlogged during the pandemic. That worked so well, the county commission, I think, is now considering keeping that model in place going forward.
So that was a flat fee contract,
Flat
not
fee.
related to anything billable hour.
Well, what's interesting is the Sixth Amendment Center came in a couple of years ago and looked at our system when we were still before there was any public defender system. And in one county, and Maine counties are geographically large. We don't have that many counties. They're geographically large. But in one county, we did the appointed system through a contract of a group of attorneys that had a flat rate contract. And the Sixth Amendment Center was very, very critical of that, as saying that, that incentivizes, if you will, the lawyers to essentially sell their clients down the river.
Who are they to say? That's outrageous.
But and the irony of it was, as a judge who actually sat in that region where there was a contract, it's a rural county. It was helpful, but ironically, it was really good lawyers who did that. In fact, of the small number of lawyers who were part of that group over the years, I think 3 or 4 of them are now judges. One of them is our governor. So it happened to be probably the best group of lawyers almost, or one of the best groups of lawyers. And that wasn't accounted for, of course, in the, in the study. So that got kind of meant that whole arrangement got thrown out without anything else.
I've heard that criticism, but I'm like you. My personal experience where I presided over cases was that those attorneys were excellent. And in this recent thing that I mentioned with the ARPA funds, I just visited with the judge that is the primary judge presiding over that, and he said he felt like he said if you look at the statistics, there actually are doing more jury trials through some of the other systems, and they're getting not guilty verdicts in many of those, at a fairly high rate, not certainly not 100%, but they're so I would argue that at least based on those anecdotal experiences, we're getting really robust service from that contract relationship. So I'd hate to cast a hardline view myself.
But somebody made a comment earlier about people making a living off of court appointments, and that's part of what's going on too. It's not just a lack of lawyers in rural areas, but in a state like Maine, we have plenty of lawyers, but we have a lot of lawyers who all they do, whether it's commercial litigation or whether it's advisory work, our largest law firms literally don't have anybody who's ever touched a criminal case, for example. It has become very stratified, whereas when, I don't know about the rest of you, but when I started practicing, we all did it. I did court appointments. My first jury trial was an armed robbery on a court-appointed basis. But I was coming from a law firm that had a really robust trial practice. I had, some of the best lawyers in the state sort of behind me, if you will. And we don't see that anymore. Starting a couple of decades ago, the practice of law has become more and more segregated into practice groups, and we have people who really make their living off of doing court appointments. I'm not sure that that's healthy, and that's part of the problem for getting lawyers back into the system to take some of these cases.
Well, we've had a public defender system since 1970. So I don't know how I got into it, but I found research that lawyers were challenging their appointment because they said it was a taking without just compensation. This is in the 60s. And so the Kentucky's highest court at the time said, no, this is part of your duty, your public obligation as a lawyer. And so the Kentucky's highest court bravely then said, okay, yeah, it's unconstitutional taking, and effective July the 1st, which actually was then the first day of the Department of Public Advocacy, that it was unconstitutional to appoint lawyers as public defenders. So it's all either Department of Public Advocacy or it's contract attorneys. So the courts don't appoint lawyers to handle criminal cases anymore.
Yeah, we've always looked at Kentucky as kind of the big question mark. What's going on in Kentucky from our standpoint? Because you don't have you have a robust public defender's office agency and the contracts, but these contracts, I'm fascinated at what you've said, that there isn't a change, because the intuition would be that if it's a flat fee contract, that they're just going to check the boxes, minimum input, maximum gain, profitability.
Well, actually, from your colleague Damon Preston, he did address that in one of the emails that we traded just in the last couple of days. And so what he said is they've raised their rates for contract attorneys, and it's a flat rate, but they get additional if they go to trial.
Okay, and I do know, and that was the question I was going to ask. We have caps on our cases dependent on where they're at in terms of dependency, neglect, and TPRs, termination of parental rights, and then we don't. It could be, we have a difference between our felonies and our misdemeanor, but they're in caps. Everybody's paid the same except in capital cases. So do you think that it's the level of rates that make contract for flat fees work?
It may be. I guess I would advocate, think about it. The value to the client is not how much time the lawyer puts on the case. It's the end result. And so I think one of the concerns was that they saw cases being resolved earlier in the process where there was a contract, whether it was at arraignment or something like that, But of course, these lawyers were getting the information ahead of time and were able to do that for cases that could be resolved or perhaps should be resolved. And for the client, oftentimes, not always, it depends on the nature of the case, an earlier resolution is a better resolution. So I would talk about that not just in the criminal arena, but in general. As somebody who spent a fair amount of time working in fees, even in the civil arena, think about it. From the client's perspective, the value is not how much time the lawyer spends on the case. You don't pay doctors more because they take longer to do the surgery.
Mm-hmm. Justice Luckert, that seems like that would be an applicable principle in how that these were contracted with firms in your state.
Right. In fact, special procedures were put in place in some of these situations so that there was expedited discovery. Most of our prosecutors, I think, have open file policies, but not necessarily where there's a real effort to make sure that immediately upon filing that happens. And so this new docket that was so successful, that was one thing they put in place, was a formal mechanism for that to occur. If I would compare that and the system that we have for criminal defense to our guardian ad litem program, which doesn't have the same requirements for experience, the same cap necessarily on at least on a regulatory basis. It may be there judge by judge, but not overall. We have a great high level of complaints that our guardian ad litems are overwhelmed. They just do not have the time to spend with the family, the children, the families that as they need to. And so I think there is something about the caps and just the system that regulates it, in contrast to it just being a system where new attorneys are finding a stable income source for at least a part of their practice.
What I didn't address, I think, is family court adequately. So our public defender system does not it covers juveniles who are charged with public offenses, but it does not cover parents in DNA cases. So those guardian ad
DNA cases?
Yeah, dependency, neglect, and abuse.
Okay.
Is that what you call it? What do you call it?
We call them child protective.
Okay, all right, we call them DNA cases.
I thought you were taking their genetic material.
There's some of that.
I thought there was going to be a paternity.
There's some of that. So the attorneys in DNA cases are basically on a list and are appointed by typically the district court judges when one of those cases is brought. And typically those are the same attorneys who might be guardian ad litems for the children. And those are paid a flat fee. And so that's actually created a problem when there's an appeal, because I don't think they get paid for the appeal. The lawyers don't. So a lot of our counties have very few. We have 120 counties. We have more counties than any state except Georgia and Texas. So in a lot of our counties, there aren't lawyers to do the DNA cases, either as to represent the parents or to represent the children. So that's a problem that we have.
And I think we probably all have that, where every time there's a child protective case, we don't always do
you mean
DNA.
A DNA case? You mean DNA case?
We call them child in need of care cases.
Every time there's a child protective case, you're looking at appointing counsel for each parent. There may be one, there may be two, there may be three or four involved in a particular case with different fathers of different children, etc. And you need a guardian ad litem. And for us, it sounds like for you, the same attorneys, frankly, who, not always, but it's often the same attorneys will do parents in one case and then they are the guardian ad litem in another case. And so, obviously a public defender system, if you have with conflicts, you can't do it all anyway. We do the guardians out of the state system, but it's another stressor on the system, making it very, very difficult.
Yeah, Tennessee, and that was going to be part of my response. I do think the guardian ad litem, juvenile, family, we call them dependency neglect cases too, and termination of parental rights cases. They're time intensive. So a flat fee,
They should be time intensive. There's a lot at stake.
right? And what we do, which I'm feeling good as I sit and listen about what we do. We actually, our DNNs are in two phases. One is predisposition, pre-adjudication, and predisposition. And so we have a separate cap, and all of our caps can be doubled if the case is determined by the local judge, the trial judge, that it's complex and extended. And then there's a separate fee and cap for phase 2 of the DNN, which is post-dispositional, that would go all the way back to, say, reunification, or if it goes into a termination, then there's a separate fee and a cap for the termination. And then if it goes to an appeal, then that's a separate claim and a separate cap that applies. So when you have a flat rate for us, it would be a much higher flat rate than what I have seen other states, and I'm not looking particularly at your states because I don't remember all of them, but like to say $500 or $600 for a DNN, that would never apply for us in Tennessee. We have a much, there's a new claim at each court level that they go to. Is there anything like that in Kentucky, the way that you all do DNNs, or is it just one?
Well, I'm actually thinking I need to get your contact information so I can. Like I think I said, for the longest time it was a flat $500.
Okay.
Start to finish. Wow. I think we have changed that to give an increase in fee if there's an appeal, but I would need to check that.
We have a cap on hours, but again, similarly, because the guardians are paid by the court, so I see those, but it is by phase of the case. So it's not per case, it's by phase of the case up through what we call the jeopardy phase, or through reviews, through termination, post-termination.
Listening to us could be folks who are just the general audience, citizens. Our podcasts go out and are available to the public. And they might be, if they've stayed with us so far over these, as we've gotten into the weeds of this, which you all have just given us great perspectives and information, but they might just say, why do we need to worry about this? It's one thing in the criminal, yeah, we understand you got to have a defender, but why do we have so many lawyers, in these child dependency neglect cases? One thing I find myself doing is explaining what is the liberty interest that's involved in these juvenile cases as well as the criminal cases. Your thoughts, kind of thinking as legal scholars that you are, how would you explain why this is important to the more general public audience that may say it's just more money coming out of our budget and it's higher taxes?
We're taking people's children away from them.
You want to make sure, as I said, that the system works as well as it can for everybody, not just those with a lot of resources, personal resources, but for those who don't have any resources. We've all had cases, either as a trial judge or as an appellate court judge, where the allegations were unfounded. But there were still allegations, and the process had to work, and you want the process to work. So that's why.
And of course, one of the things that's very different in those cases from a criminal case, the goal is the protection of the child, but it is also to try to keep the family intact. And so they are resource intensive. We're trying to, when there is a problem, you're trying to fix it. You're trying to make sure that this child can stay with the parents, that the parents can take care of this child. And it takes all of the players in the system to make sure that we're not blowing up our families all over this country. We've got some problems going on.
My predecessor, John Minton, when he was a trial judge, he told a story about a case involving termination of parental rights. And these children had been absolutely abused. And so he ended up, it was clear that termination had to occur. But he interviewed the oldest child, who was maybe 8 or 9, and the child was just like, please don't take my mom and dad away. Notwithstanding the horrible things this child had abused, he still wants to stay with his parents because that's all he knows, right? So. Well,
and I think children also know that they're losing the sense of a family. Once they're in the child welfare system, they often at least have a long period without that sense of family, or sometimes a lifetime. And that's a huge loss for a child. So we do have a duty, and I know, despite the fact that we have in our state struggled to really find good solutions for getting the attorney coverage for that part of the system. We have gotten good support from the legislature to start building the specialty court model into our child in need of care program. So we're starting to do special dockets modeled after the criminal dockets when there are alcohol or substance abuse issues that are kind of underlying the problems the family's facing. So we're seeing, at least, and I appreciate from our legislature, a desire to help solve this problem, and frankly, a lot of that means putting more money into the system. And so, at least in our state, the legislature is responding in that way.
And we've had a great deal of success with our family treatment and recovery courts. I'm very proud of it, and reunifying and keeping the families intact. I'd like to expand it, but they are resource intensive. And it's not just resource intensive for the courts, it's the community resources for treatment and the like.
But I was just at a CLE in Sumner County, Tennessee, and as the juvenile judge said, when you see it working, it's an amazing thing, and it's effective. And those programs are excellent coming through the recovery. I have to ask you though, I'm gonna drill down just a little bit on this, because we've talked about the child welfare side of things, and that is certainly thing that maybe people misunderstand because they want to see, those horrible parents, and they don't realize this is a fundamental right to parent, as you brought up, Justice VanMeter. But what about the juvenile? And by that I mean the juvenile delinquency. We sort of have two sides of this, where we talk about an unruly, which is kind of just like a truancy, but then what about the juvenile who commits the misdemeanor or the felony? How is that different from your view and what's done in your states? Any input on that?
We have a pretty robust juvenile system that goes toward the therapeutic side rather than to the penal side. It is more difficult, not as difficult as it used to be, but more difficult in Maine, for example, to try a juvenile as an adult than it is in many states. So underage, it's very rare for a juvenile to be brought into the adult system. And same thing, we're trying to keep families intact. We're trying to change the course of this young person's life, of the youth, to try to keep them as productive members of society. When I would do juvenile court in the day, I would ask some of these kids, it was like, so 5 years from now, what are you thinking? And you're trying to change the course of what's going on in their lives. But that also, it takes work from the lawyer, it takes work from all of the players and the community.
So when I was a juvenile court judge, the way I saw it
Did you know we were all juvenile court judges too?
Well, the way I saw it was I was trying to give the parents, a backbone. What I saw in juvenile court, the common denominator was a child who was maybe living with a grandparent, single parent home, or that the parents, if there were two parents, they were both working. There was no supervision and there was no discipline. Not discipline in the sense of physical punishment, but this is the expectation of what you're going to do. And actually that, in my view, that laps over into the criminal justice system as well, that a lot of people who are offenders, they don't have that upbringing that we saw in juvenile court. But we have, and I'm sure it's the same in Kansas and Maine, that in juvenile court you have public offenders who commit crimes that are crimes for anyone. You also have status offenders. So those are runaways, truancy, and beyond control. That if you and I don't do, if I don't obey my parents, nobody cares. But if someone's under 18, we care, because we want that family to operate as well as it can.
We do a lot of diversion, so they don't come to court, I think, is what happens. We don't have don't have the status. No, we literally never see them. They're diverted before, so we only see actual things
Public
that would be
offenders.
Offenses if it was otherwise.
So actually in Kentucky, they are typically diverted again and again and again. And then after like the fourth or fifth time, then they do come to court, which also is a problem, because There's one theory for juvenile justice that if you smack them pretty hard the first time, they don't come back. But if they're continually diverted and giving, minimal, sanction, they think it's not a big deal. The juveniles do. So, I don't know.
In Tennessee, most of our public defenders' offices are too taxed to take on a lot of these cases, so it's a lot of private counsel being appointed. What about Kansas?
Kansas does not have a statewide system, so it's county by county for our juvenile defense. And so it does vary widely throughout the state but I think often, I think there are a few places where we really have some committed attorneys who really do want to focus on this. Others, it's just another part of their criminal practice or family law practice sometimes, depending on how that happens. So,
is there anything we're missing as a whole across the United States, or any final thoughts you would have about indigent representation?
Well, there are 2 points that one which we really haven't touched on exactly, and it's the conversation I have a lot as I do talk to legislators and others, and that is that the judicial system on the criminal, juvenile, and the indigents, where we are dealing with the indigent defenses and attorneys that are representing people who can't afford their own attorneys, is that what we're really talking about in the judicial system as a whole is a three-legged stool. We depend upon the prosecutors or the state's attorneys that are bringing those cases. We depend upon the people representing the families or the children or the defendants, and without that, the judicial system itself can't run smoothly or efficiently. It bogs us down in terms of what we try to do as judges. And it is, the other thing I would talk about is that I do think that the profession of the practice of law has shifted, at least in what I see in my state from the time I started practicing until today. You were going to do pro bono work, whether it was on the civil side or the criminal side or a mix of both. And we just don't see that today. And in fact, our judges express a reluctance that they would want to be in a situation where they had to demand that of their bar. So it's a very different mindset than it used to be. And frankly, it's a mindset that I don't think serves our profession well. I think it changes the way we look at our communities and and ourselves and the role of the law and in the community and in the community's welfare.
Yeah. Justice VanMeter, anything you would?
You want to ensure that the system does not run rampant over people who are pro se or don't have an attorney. You just don't want that. I mean, to the extent it does, it crowds up our prisons and our jails, and that's bad. It bogs down the system because you need someone to shepherd through cases in a more efficient way. Not that the court system is all about efficiency, but inefficiency it bogs it down really, really bad.
Justice Stanfill?
We have a lot of different things in our society that are sort of coming to a head, I think. Some changes that have been happening over the last number of decades that are coming together to create a crisis of constitutional dimensions. It certainly is for us. We can talk about how we looked at it. We're all old. When we started doing this, it was pro bono, we could do it. But the practice of law has changed, and we need competent representation. And if a lawyer has never done anything except draft a will, I'm not sure that person is competent to represent a criminal defendant in a serious felony case. So we've got a tension that is being created in the way in which the practice of law, and frankly, it's not just law, this is happening in all professions, the lack of rural practitioners in the medical field, etc. So we've got that. But I guess my parting thoughts, and this is something I say, it's not a court problem. It's not even a lawyer problem. It's our society. It's all of us. It's how we are keeping families intact, how we are administering justice, how we are preserving access to meaningful justice. It's a problem for all of us, not just the courts and not just lawyers.
All three of you have been very eloquent and really insightful. On behalf of Director Long, the AOC, and Chief Justice Kirby, we thank you for taking the time today, for being with us, and thank you for your input on this important topic.